been a 3-month-old born of the parties, although no paternity finding, since 24 DM 15, Kendall Pierce versus Michelle Ray, which involved the oldest child that's only a year and a half, I think, 18 months or 2.5, year and a half or 2.5. Anyway, yeah, 24, 25, 2.5. Counsel, frankly, that there is reason to file a new case for the additional child, obviously. But I will, and Ms. Orchard appears on behalf of, in the divorce case, the 25 case, the petitioner, in the 24 DM 15 paternity case, the respondent, and Ms. Locke appears for the petitioner in 24 DM 15 and for the respondent in 25 DM 465. There is reason to include the additional child. But honestly, had I paid attention, I usually look at other documents that aren't part of my queue as needed. And I looked at the affidavit. I always look at the DRA. But I didn't look at the UCC JEA to realize that there was a paternity case. And because I probably wouldn't have signed any temporary orders and just set it up for a hearing to establish temporary orders. And especially since Ms. Locke was still an attorney of record on the paternity case. So the other thing I'm just going to mention, I'm not prejudging this case at all, Ms. Orchard, but unless I've missed something since law school, a affidavit of common law to obtain insurance or anything else for that matter isn't per se a common law marriage. I mean, you have to establish capacity, you have to establish present intent and holding themselves out. Now, certainly an affidavit is holding themselves out for the benefit of the parties, saying that they're common law married, and maybe they are, but I think that if your client was going to assert common law marriage, she probably should have done it in the paternity matter. But again, there's nothing that says she can't file a divorce and ask the court to find, although it is her burden of proof that they are common law married. We do need some temporary orders, though, if these parties are no longer living together. The other thing is, I've had divorce cases where they've stayed living together after the divorce and sharing the kids. Not the greatest idea, but somebody lives upstairs, somebody lives downstairs. I don't know. I didn't realize in this case, though, that they not only continued to live together when and there were final orders. I wanted to check that. There were final orders entered by agreement on March 7th of 24 for the oldest child. But I also didn't realize that they additionally had another child. The parenting plan for the 2.5-year-old involved every other weekend for dad and Tuesday night and Thursday night. And you've alleged that they haven't been exercising that because for the most part they live together and they never really entered into that parenting plan, even though it was adopted by the court and found to be in the best interests. Now, your proposal for temporary orders, which again, I have not had a common law. It's kind of like the question with paternity cases. Can you really do interlocutory orders before you find that there's a marriage? I don't know, but we need temporary orders and need temporary orders for both kids. And you're proposing that he have every other weekend. And for the baby, that's 3 or 4 months old or whatever, that he get the baby from Saturday to Sunday, and he get the 2.5-year-old from Friday to Sunday. Is that correct?
Yes, more or less. The parenting plan was every other weekend for the 2.5-year-old, and then Friday to Sunday, 6 to 6, and then Saturday 1 to 6 and Sunday 1 to 6 to be on the same schedule as the every other weekend. That is what my client thought was in the children's best interest. And we can go into why she thinks that or anything, but just to answer your question, essentially, yes, you had it correct for the proposed parenting plan and the temporary orders.
Okay. Well, and by the way, Ms. Locke, I sign those temporary orders. The clerk won't withdraw them for me at my request. I have to actually file an order to either modify or rescind that order. But I guess the question, Ms. Orchard, is your client breastfeeding?
Yes, she is, Your Honor.
Does she pump? Can she send milk?
Yes, she sends milk to daycare, I know, during the day. So she is able to send him with milk during the day. I do know that.
Okay. So, Ms. Locke, have you talked to your client about these new proposed the parenting plan that would include both children?
So, Your Honor, prior to Ms. Beckman sending me these documents, I was not aware of the divorce. And in speaking with my client yesterday, my understanding is that the parties have been doing the prior paternity action parenting plan with both kids. That he has had the baby, he had her on Tuesday night. She went home with mom overnight on Tuesday. And that his intention was to pick them both up from daycare today and have them today as he would in the normal parenting time. So he's not in agreement to, just because now she wants to allege that they're divorced, to modify what they had already agreed to. She has already provided him with milk. So, and from his statement, there is plenty of breast milk, and that's not real. Supply is not really a concern. So we're not in agreement to say that suddenly, because they're going to be living apart from each other, he should have less contact with his daughters.
So the baby is not spending the night.
She is capable of spending the night. He's perfectly capable of keeping her overnight, but he didn't want to rock the boat, so he allowed the infant only to go back to mom overnight on Tuesday.
So how far apart do they live from each other?
My understanding is that she has been in their residence, and he, not their residence, it's his home, but he chose to remove himself from the situation because there were some odd things happening, and that she was going to vacate the house. I'm not sure exactly how far apart they are, but I would allow Kendall to speak to inform the court.
8
Well,
miles.
8 miles.
The temporary order places your client back in the house, right?
Correct. If the temporary order stands, he would be back in the house. He has no idea what her plans are as far as where she would be moving to or what location she would be living in. That is unclear to him.
Okay. Ms. Orchard, does your client have a plan?
Yes, we discussed that before we filed, and she said she did have somewhere else to go.
How far away is she going to be?
That I don't know. How far away, Michelle, is where you're going from the marital residence or the residence you guys have been living in, if that's disputed?
El Dorado. So less than 10 miles.
Okay. Yeah, Mr. Pierce, you're entitled to have an address where your kids are, but I just don't think we need to say it during this proceeding, give out that kind of information.
Your Honor, sorry.
I'm just going to say this. I'm not an expert, but breastfeeding includes skin to skin contact and nurturing and all that a child gets from that than just a bottle. So I think you can supplement some, but there's still, if she's desiring to nurse, there's value in the nursing, not only in getting breast milk, but also in the close contact and security and all those great things that it does for a baby. That's not to say dad shouldn't be bonding with this baby, and that's equally as important. But I think there might be a good reason to limit the overnights with the infant for a while anyway. How long, Michelle, did you breastfeed your first child?
I breastfed Brixton almost 5 months, and then I had taken some medicine that forced me to dry up when I was sick. And so this time I had hoped to make it to a year
Okay.
because this is my last baby. So
Well, and I think another 3 months may make a big difference, but, and certainly the child needs this going into the winter for its immune system. Okay. The other thing I wanted to say, I'm sorry, I've been kind of sick this week. I kind of have a little bit of brain fog. The other thing that I wanted to say too is I do understand why a couple could stay together and file a paternity case just to make sure if one party leaves or the other that they've established some rights. There are some states where you have to. But I think probably for temporary purposes, that's the direction I would like to go. So Tuesday, Thursday night with baby, and Saturday and Sunday with the hours proposed with baby, and the regular schedule for the 2.5-year-old.
Your
And then
Honor,
yes,
you said the hours proposed, that would be limited from 1 p.m. to 6 p.m., or he gets the same all day, it's just not overnight.
well, I don't know that you need to be making a million trips. So I would say when he's not picking up the other child that morning.
Right.
I mean, I don't know why he couldn't do 10 to 6 or 10 to 5 or I think 6 hours minimum is probably appropriate, whatever time it is. Instead of 4. So I didn't remember. Let me see
Okay.
here.
And Miss Locke and I can talk and see if there's a set of 6 hours those days that they would prefer.
Okay.
What times do you have in mind, Judge, for the Tuesday, Thursday for the youngest, if it's not to include overnight?
Whatever. Oh,
Right now it's daycare pickup until daycare drop off, but I think that they did they exchanged the infant in the evening on Tuesday evening. I think the parties just agreed upon that time.
yeah, it's not going to be 6 hours.
Right.
Um,
Because of daycare.
yeah, I mean, but like 2, 2.5, 3. You don't know the schedule of the baby. They know that best. You probably want to transport the baby when, is it a girl or a boy?
Both girls.
Those girls, when she's sleeping, or when she's sleepy, not when she's hungry. So, I'm gonna let you kind of figure those details out. I think you can do that. What I didn't know is whether or not you had proposed something for the holidays, for Christmas.
No, and my client did tell me today that we do need some orders for that. According to my client, she says that dad had 5 days for Thanksgiving to take the child to Texas with his family. And so they had planned, I think well before this was filed, for her to have the 23rd through the 29th to take the children with her to her mom's for Christmas. So I haven't had a chance since the emails last night till the hearing today to talk with Ms. Locke about that to see if that's something he will still agree with. So I thought I'd just bring it up now in the hearing since we're here.
Your Honor, I had not been made aware of that. Our suggestion would be that the holiday plan that's in the paternity action be maintained, since that is the holiday plan that was previously ordered.
Well, it sounds like their primary family gatherings are out of town for both of them. So, and I think if he made an agreement with her,
And I don't know that that is true.
right, I know,
This is the first time I've heard that.
right. If,
Yeah,
but
I
that-
apologize.
if that is true, I think you ought to stick to it this time. Typically, I prefer Christmas to be split up, especially when people are close together. Somebody gets Christmas Eve, somebody gets Christmas Day. You flip flop, or you keep it that way indefinitely. Again, I can't know what your traditions are, and you all know best. And some of those things you're going to have to sort out, compromise, and negotiate, and come to an agreement on, for
And-
your well-being and for the children's.
And I would be happy to have a conversation with Miss Orchard trying to sort out
Okay,
a reasonable holiday schedule.
okay. All right, why don't you try to do that? I'm trying to think here, the best way to approach. I almost think that in the paternity case, there should be a recognition of the new child. And there should be a modification of that parenting plan temporarily and relate it to both children.
And Your Honor, I will fully disclose to the court that I filed a paternity action with the new child today. And the reason for that is I'm going to file a motion to dismiss in the divorce case, and there needed to be a backstop for the younger child in the event that the divorce case does get dismissed. And so I didn't ask for any parenting time or anything, but just for paternity to be established in favor of Mr. Pierce.
Okay. Well, I don't think there's any dispute about paternity, but again, ultimately, I'm going to want the kids under one case file. And so I think that the paternity case ought to reflect what I've ordered today. And then I think it could be journalized in the divorce case with the proviso that there is no agreement that there is a marriage, but these are the temporary orders as it pertains to the kids. That's still in controversy. And then you can file your motion to dismiss, and I can schedule it for trial if need be. I don't know that this is going to be a summary judgment kind of thing. I'm not sure what your motion to dismiss is about, but these are kind of the problems that you can run into. I don't know where he works, but people at the prison seem to do that all the time. And
Your
then
Honor,
it comes back to bite them.
our position would be that the court doesn't have subject matter jurisdiction over a marriage if there is no marriage. So you can't have a divorce action if there isn't a marriage. So that needs to be proved up before we would proceed with any orders or anything.
The mother's attorney claims there was already an agreement for Christmas. She would take the children to visit her family out of town from December 23rd through the 29th.
Looking like a divorce. And so we would ask that, based on the pleadings alone, that there cannot possibly be a marriage and the court can't hear anything having to do with the marriage. So I filed only a limited entry of appearance in the divorce case because we are not going to answer or do anything related to the divorce because we don't believe there should be a divorce action at all.
Well, I think what she's saying is, hey, I've got a prima facie evidence with this affidavit that there was.
And
There
that
wasn't
affidavit was not included in any of the pleadings.
Okay.
Correct. It has been provided, though. You have received it. Both of them. There's two.
Guys, I'm just needing you to help me here to logistically figure out what we need to do with the court files, because I think I need to rescind the temporary order in the, well, I've got a copy of the declaration here. I think I need to rescind the temporary orders in the 25 case. And it could just reference then that all orders as it pertains to the children will be in the two paternity cases. But I'll want you to consolidate those two cases. And then I'm gonna have to decide evidentiary wise whether there's a common law marriage or not, set up a trial. And I'll entertain your motion to dismiss. I mean, I'm not understanding your jurisdiction argument. When somebody asserts a common law marriage, yes, there probably shouldn't be any interlocutory orders because the argument you're making is nobody's found that they're married. So there shouldn't be any interlocutory orders entered. But if somebody files and claims common law and they serve the other side, it has to be litigated. And the position you're taking is like, well, no, you never have subject matter jurisdiction, so you can't even litigate it.
So they would have to establish that there is a marriage. And my position is that based on the pleadings alone, they have not done enough to establish that.
Okay,
Because the affidavit, like I said, is not of the court file. And so it obviously, if it gets filed and is offered to support their petition, but based on the petition alone, there is not sufficient evidence to establish that these parties were married.
okay. Well,
I think personally, I think it's a factual issue, but as far as which would require testimony and litigation. But we'll chat, like I said, when you file a case as an attorney, I haven't spoken with Mr. Pierce about that he thought that there was going to be no marriage or he disagrees with that or anything like that. When you file a petition, you file it with the information and the evidence that you have, but it's also not common practice to file evidence in the court file when you file a petition for a divorce. When I spoke with my client, I believe there was sufficient evidence to file a divorce, but regardless, I do think it would be a factual issue for an evidentiary hearing at a later time, but solving the imminent problem that's in front of us. I'm fine, Ms. Locke, if we want to do an agreed order consolidating the paternity cases and submit the order from today, the parenting plan. So at least we have that. That was my concern yesterday. Is I get that we're going to need time to clear all this up, but I do think these parties really need some orders in the meantime so that we can have as little conflict as possible. So
okay.
whatever we can do to get
And
that
then
done.
in the divorce case, then you're going to acknowledge the other cases, that this case came on for hearing, that the court made certain findings that will be journalized and reference the paternity case, and that this matter will be scheduled for trial.
Yes, and I can put in the journal entry that, he uh, disputed the existence
Okay.
of a common law marriage.
The debate becomes a classic legal clash, jurisdiction versus factual determination. And it's clear that this issue won't be resolved today.
But that we did acknowledge paternity, and then that can be in the paternity file as well. The acknowledgement of paternity. I don't think anybody agrees or disagrees about paternity.
I doubt you'll get a trial date. You may have to do some discovery, actually.
Right.
Do you think you could try the common law case on January the 29th?
That sounds like something I already have something booked for. Let me look. Yeah, unfortunately, I already have a couple other hearings that day.
Okay.
And I do think we need some time. I mean, I'd like to see her motion to dismiss so that way I could file a response and then,
Okay.
discovery if that will proceed and all of that. So,
And
How
the
about-
intention of the motion to dismiss will not be to shift the burden of proof, because the burden will be on the petitioner to establish that there is a common law marriage.
Right. And I would ask if you're gonna amend your petition and file that affidavit as an exhibit, that you do it under seal. Because
Yeah,
I think
the
there's
forms are-
probably, first of all, there's always concerns about fraud, but secondly, really, there's a lot of personal information that I don't want the public to have at their disposal. I'm sorry, I'm looking here. I guess I have at 2:00. Okay, so what about February the 4th?
that looks good for me.
It is open for me too, but I am in trial with Your Honor on Thursday and Friday that week.
Yes.
So I would not prefer to back them up to each other, but I can if that is the only thing that's available.
Well, I mean,
I don't foresee, if we can agree on the parenting issues, I don't think either party has like this financial need or this housing need or some big concern as far as if there's these allegations or there is proof of some sort of marriage and marital property needs to be divided. If we can get some consistency with the kids, I think that will alleviate a lot of the issues that are going on in the case.
yeah. Well, and there's a lot to consider. I mean, you can still divide property without binding in a marriage, but you also can tell your children that it was declared that you were married during the birth of the children. So I don't know. I mean, I don't know what, I guess, the reasoning is or what is necessary and what's not necessary, but otherwise I end up March 4th, truthfully. And either place, I've got a 2-day domestic trial on Thursday and Friday that follow when this trial would be. But that's your choice, February 4th or March 4th.
Do either. And I understand not wanting to have trials 3 days in a row. I get that. So,
I have trial 3 days in a row on the March date, but it's a sync termination and I'm not a parent's attorney, so I would prefer March 4th because it's
All
going
right.
to require less prep.
Okay, so put in the 25 case that unless I get the motion and you respond and we want to have a hearing on that sooner, but March the 4th, that's the trial date to determine whether or not there was a common law marriage.
And Judge, do you want to include that other case that Ms. Locke was referring to that she just filed today?
The immediate priority is stability for the children. She decides that the two paternity cases should be consolidated so that both children are handled under the same legal file.
The other paternity case? So you have a
yeah,
divorce
they're gonna
in
be
two-
consolidated. So,
Okay.
all right, anything, and
Should that get assigned to Judge
that won't
Satterfield?
get us quite 90 more days, but
It is assigned to Judge Satterfield.
we
Susan.
should be able to at least talk about in March some extension of parenting time with the baby and when that is in the baby's best interest. 6 months, 9 months, a year.
Okay, so we would like to address, unless it's resolved, of course, by agreement before that, at the March 4th, we would address the parenting time as well for the paternity cases.
Yes.
Okay.
Review them. Yeah, review the status of them.
Okay. Yeah, just to make sure I was prepared.
Yeah, sure.
So that'll be a status review for parenting time, not a trial on parenting time. It's a trial on whether or not there's a common law marriage.
Right.
Okay.
All right. Anything further today?
I just want to
No.
make sure we have March 4th, a trial on common law marriage from 9 to 5 in person.
Yes,
have
I
that
have to
right?
break for first appearances. That's my duty day, but yes.
March 4th is Judge Hart's duty day.
Oh, okay.
That February date was your
Okay, I'm
duty
sorry.
day.
Okay, yeah, March 4th, 9 to 5.
And I will file the order consolidating the paternity actions and an updated parenting plan after talking to Miss Orchard in the paternity actions.
And Miss Orchard will journalize what's happened in the 25 case.
Okay.
And then, so your position is he still has an obligation of support. So she ran a worksheet. And it's about 900 and some a month. That means
Your Honor, our position would be that that needs to be adjusted because that was based on a more limited parenting time schedule with no parenting time adjustment.
We will need to do a shared worksheet or whatever that works out to be. I haven't run a parenting time calculator on the paternity, but it
please work on that. Don't let somebody end up unable to keep the lights on over Christmas. So, see if you can't include a child support worksheet so they have something to go by.
As the hearing wraps up, the judge delivers a final reminder that cuts through all the legal arguments. No matter what happens with the marriage dispute, two young children remain at the center of this conflict. The court orders both attorneys to prepare updated parenting plans and calculate child support adjustments based on the temporary schedule. The current estimate places support at around $900 per month, but that number could change depending on parenting time. The judge encourages both sides to cooperate so neither parent faces financial hardship during the holidays. And with that, the courtroom slowly settles. The legal battle over marriage will continue, but for now, the court's focus is clear: protect the children, maintain stability, and give the parents time to figure out the rest.